Good morning. Our first case this morning is State versus Thomas, and we will hear from the appellant.
Good morning. May it please the court, Chief Justice and Associate Justices. My name is Gilda Rodriguez, and I represent the appellant, Mr. Thomas. I would like to reserve 7 minutes for my rebuttal. Mr. Thomas had 13 convictions at his first trial. He exercised his right to appeal and was successful. His convictions were vacated and he received a new trial. At the new trial, some charges were dismissed. The jury returned one not guilty verdict, and he was ultimately convicted of 5 felonies and 3 misdemeanors. And yet, Mr. Thomas received a longer active sentence. Mr. Thomas's sentence violated General Statute 15A 1335 because the sentence imposed in the second trial was not a statutorily mandated sentence, and the Court of Appeals decision is inconsistent with this court's opinion in State versus Wagner. 15A 1335 was enacted in response to a United States Supreme Court case, North Carolina versus Pierce, which held that when a trial court imposes a more severe sentence after a new trial, that the trial court is required to include in the record the reasons for the increased punishment. Pierce court explained that due process requires that vindictiveness play no part in the sentence a defendant receives after a new trial. It further explained that the fear of vindictiveness may unconstitutionally prevent a defendant from exercising his right to appeal or collateral attack his conviction, and due process requires that a defendant be freed of fearing such retaliation. In North Carolina, our legislature took Pierce a step further and afforded individuals in our state greater protection because it does not provide for a more severe sentence at resentencing. In fact, the official commentary states that 15A 1335 embodies Pierce, but does not allow a more severe sentence when even if intervening factors would argue for a more severe sentence. This court addressed 15A 1335 in State versus Wagner and held that when the sentence from the sentencing charge at the second trial is in conflict with 15A 1335, that 15A 1335 prevails.
Can I ask you, I had a question about just how when the trial court was consolidating these offenses at sentencing, is it your position that the way the court consolidated them resulted in that extra point for the elements matching the prior offense provision, or was there really, in other words, was there some way in the court's discretion in consolidating the different offenses that it could have structured it so that that one point didn't apply?
Yes, that is my.
And that would have been so the court had discretion to say, I'm going to consolidate them this way, that created the requirement in the structured sentencing statutes that this must be your prior record level. And the court could have done it a different way.
Correct. The judge has discretion on how he wants to consolidate. The only requirement is that the most serious felony be the leading felony, that the punishment would go according to that one, and the leading felony is also the one that would dictate whether or not the additional elements point would be added or not.
That was what I was trying to clarify. So in other words, if it's only that, if you're consolidating other offenses into an offense, it's only that offense that remains that you're looking at to compare the elements for that extra point.
Correct.
And so your argument is the court had discretion to choose a different felony to be the one to consolidate some under, where you wouldn't end up with that extra point added, so it would have been like the original sentencing.
Exactly. And in fact, in this case, the sentencing transcript shows that 15A 1335 wasn't even considered. It was never uttered at all during, so it almost seems like the judge and the prosecutor proceeded without being mindful of 15A 1335. And had he been, he could have seen that he could have consolidated things differently and not have triggered the additional elements point. In Wagner, the defendant was sentenced to a mitigated sentence following a guilty plea. The defendant filed an MAR because he believed his prior record level was incorrect. the conviction was vacated, the defendant was tried, and the jury returned a guilty verdict. The trial court sentenced the defendant to a presumptive sentence, which was greater than the mitigated sentence he originally had, and he appealed. The Wagner court cited 15A 1340.13b, which provides that a defendant should be sentenced according to the sentencing chart unless an applicable statute requires or authorizes another minimum sentence, and held that in that case, 15A 1335 was the applicable statute requiring another minimum sentence. In the Wagner case, 15A 1335 required the defendant be sentenced to the original mitigated sentence. Here too, 15A 1335 should prevail, and Mr. Thomas should receive a sentence that does not exceed the sentence he received at his first trial. The state will argue that the sentence imposed in the first trial was wrong because the additional point was not assessed. To that, I would argue a few points. First, at the first trial, the state and the trial court both discussed that Mr. Thomas was at prior record level 3 and that he would be sentenced accordingly. The transcript from the sentencing hearing shows that the additional point was not even discussed. The breaking and entering a motor vehicle was not chosen so that an additional point could be assessed. The state, who bears the burden of proof at sentencing, said nothing about the applicability of the sentencing point. Mr. Thomas was also convicted of financial card theft at the first trial, which would have...
I'm sorry.
No, please.
Suppose we do think that the trial court erred in the first sentencing. Is it your position that under 1335, the defendant gets the benefit of that?
Yes, because one is that it could always be, there are several reasons. One is that there's nothing in the record that indicates that they meant to have that additional elements point triggered, because all along the discussion was on a prior record level 3.
Right, but I'm saying suppose the trial court did make a mistake and the sentence was effectively unlawful.
Yes.
Your position is, regardless, under 1335, the sentence on remand can't exceed that prior illegal sentence.
Correct. And there are a couple of cases that can be used as an example. I have here in case State versus Ransom was a case where the defendant was initially sentenced to 20 years, and that 20-year conviction was illegal. The maximum was 10 years. And so it was remanded, he was resentenced, and the judge, using his discretion, reconsolidated the offenses. And when he reconsolidated the offenses, it totaled 18 years. And he said that that was too much because it was more than 10 years. And the Court of Appeal said, use the 20-year illegal initial sentence as a benchmark to decide that it was not in violation of 15A 1335. And there was also another example of State versus Holt, where the defendant was sentenced under structured sentencing. But then it turned out that the offense was committed while Fair Sentencing Act was in place. So she was resentenced, and in the resentencing, they gave her life imprisonment. And when the Court of Appeal said that that violated 15A 1335, they used the initial sentence that was incorrect, that was unlawful because it was under structured sentencing as opposed to fair sentencing, and used that to measure that what the Court of Appeals remanded, said that that was the maximum that she could be sentenced to, was what she had received under the structured sentencing initially.
So obviously whenever we construe a statute, we're concerned with legislative intent. So you think the legislature, in enacting 1335, you think that what you've said is consistent with legislative intent, that it was the intent of the legislature that if a defendant is sentenced contrary to the Structured Sentencing Act, that nonetheless 1335 kicks in?
Yes, the statute is supposed to embody Pierce, which is trying to protect due process for the person who's appealing. so that the person does not feel inhibited from proceeding to challenge his right to a trial, his right to an appeal, because he has to make this risk analysis that someone's going to come after him for more time. And also, you have to look at the sentencing, and in this case, the sentencing at the second trial, the prosecutor was trying to add more felonies in his prior record level that the judge refused to accept some of those. He added the additional point, so it starts to have that tinge of vindictiveness. And those are the things that the legislature tried to embody in 1335 after Pierce, that there should not be that risk or that fear of retaliation because you exercise your right to an appeal.
So you believe 1335 encompasses the presumption of vindictiveness?
Yes, because the legislature passed it in response to North Carolina versus Pierce, and that case was about eliminating the fear of vindictiveness at resentencing following a successful appeal.
So what does severe mean in the statute?
I think any additional time you have to serve in prison and be deprived of your liberty is severe.
Well, I think that's certainly reasonable reading. Could it also be that if you're given unsupervised probation, you appeal, it's vacated, and then you've been given an active sentence or supervised probation, that's more severe?
Your liberties are still restricted. You still have to you still have to report in, you might have to live by a curfew, you would have to pay monthly supervision fees. It's still not the same as being able to be free. It's still restricted.
Right, but you would agree that that would be a reasonable ruling, a reasonable interpretation of the word severe as well, right?
I'm sorry, say that again?
Do you agree that that interpretation of severe would be reasonable as well, that it could encompass a probationary sentence that's elevated to an active sentence, or an unsupervised probation that's elevated to supervised probation?
Yes, I would agree that anything that does not get him to the original sentence at the very least would be severe. And I also, okay, there it is, the question. So I mentioned those two examples, Ransom and Holt, that used the original sentence, or the original sentence that was illegal as the benchmark to determine whether 15A-1335 was violated or not. And in this case, the Court of Appeals focused on the sentence from the second trial.
I'm sorry,
Sure.
Counsel, I apologize.
No.
So if you believe that 1335 encompasses this presumption of vindictiveness, why shouldn't we read the more severe language as allowing us to question or sort of insert this presumption of vindictiveness into our inquiry?
So are you asking, should we read vindictiveness into this inquiry?
Well, if Pierce, as you've indicated, you've read it, encompasses a presumption of vindictiveness, the statute is based on Pierce, what do we do with a presumption of vindictiveness?
Well, I suppose that I would say that 15A-1335 takes away that presumption, because there is this neutral rule that you don't cross, and by not crossing it, the element of vindictiveness is taken away. So for the defendant appellant, he doesn't have to fear that if he succeeds, he has to go back to a courtroom where the state may not be happy with having to go through this again and have some vindictiveness. So I think it eliminates that vindictiveness, that presumption of vindictiveness in a resentencing, and tries to make it so that the defendant is not making this risk analysis of whether he proceeds with his constitutional rights or he sits in silence.
Okay, I'm just confused because that gets to the due process concerns in the Supreme Court case, which I thought you said was sort of encompassed in the statute. And now am I correct in you saying that the presumption of vindictiveness has nothing to do with statute?
I'm sorry, I maybe I misspoke, but no, that's not what I'm saying. I think it's underlying the statute, and that's why the statute is there. But the statute eliminates that concern for the defendant appellant that vindictiveness is going to be there, is what I'm trying to say. The whole concern with vindictiveness is underlying 15A1335, but it makes it neutral so that you can proceed and not fear that you're going to encounter retaliation at a resentencing.
Okay, so I guess my question is, if 1335 is sort of undergirded or supported by this presumption of vindictiveness from peers, then why isn't that a statutory mandate would overcome that presumption? In other words, the statute wouldn't apply if we're dealing with the statutory mandate in 1340.
You would have to go back to the legislature. They would have certain statutes that say this is how it has to be implemented this way, and there's no exception to it. In the sentencing chart, 15A 1340.13b specifically says that if you are following the sentencing chart, there are situations where you have to yield, and 1335 is one of those statutes that this court has interpreted as one that you yield to. So the Court of Appeals in this case focused on the second trial and incorrectly held that the court was not statutorily authorized to impose any lesser sentence. The Court of Appeals opinions held that the sentence at the second trial was correct because it was statutorily required. Here, the additional elements point was not statutorily required at the second trial for a couple of reasons, and this is what Justice Dietz was asking about earlier. And the trial court had the discretion to consolidate the convictions as it saw fit and could have chosen a different leading felony for the consolidation of the second judgment. Mr. Thomas was also convicted of financial card theft in the second trial, which is the same felony class as breaking and entering of a motor vehicle, and it could have been used as a leading felony for consolidation, which would have avoided triggering the same elements point. Secondly, Wagner held that 15A 1335 prevails over the sentencing chart and used the case of State versus Wall to illustrate that a statute that imposes a statutorily mandated sentence, one that does have a statutorily mandated sentence, and one that yields to 15A 1335.
Can I ask you about
Sure.
Wagner? Because the state distinguishes Wagner by saying that it doesn't prohibit the imposition of a harsher punishment on remand in non-discretionary circumstances. And as I hear your argument this morning, are you suggesting that Wagner does apply here because this was a discretionary circumstance?
I think Wagner applies here for two reasons. One, because it involves a sentencing chart sentence, and Wagner addressed the sentencing chart sentence in that case that 15A 1335 prevails over a sentencing chart sentence. And two, I'm sorry, back to your question.
Well, I'm just trying to get your response to the state's argument that Wagner doesn't apply here. And their argument, at least in part, is that it doesn't apply in non-discretionary circumstances. That is to say, Wagner, the state's contention, as I understand it, is that Wagner was a situation where the judge had the discretion to not apply a harsher sentence, and so it was the judge's discretion in that case. And I might have some other questions about whether that's correct. But as I hear you this morning, you're saying here the judge did have the discretion. It wasn't statutorily mandated that he impose a higher sentence. He had the discretion to consolidate the offenses differently and sentence according to 1335.
That's absolutely correct, and that's what Justice Steets was asking about earlier too, that in this case, he had, for the second judgment, he had 2 felonies that had the same class level, that he could have chosen either one to be the leading felony of that second judgment. So he could have chosen the other one for which there was no prior offense that they could use the additional points element for. And so
then your point would be, even under the state's reading of Wagner, it's directly on square with this case and applies here.
correct, yes. So as I was saying, that in Wagner, they used Wall to illustrate a statutorily mandated sentence statute. And in Wall, if the defendant had been sentenced to, was serving a sentence for something else, and then he was subsequently convicted for burglary. And at the time, there was a statute that specifically stated that burglary sentence must run at the expiration of the sentence being served. The Department of Corrections changed the sentence to consecutive sentences, and the defendant filed an MAR, and the trial court said that it should be concurrent because that was according to the plea agreement that the defendant had entered. The Department of Corrections petitioned this court, and this court held that the statute specifically required the burglary sentence could only start at the expiration of the sentence the defendant was serving. So Wall addressed a sentencing issue that was not covered by the sentencing chart. Wall addressed a statutorily mandated sentence, which the Wagner court distinguished from a sentencing chart sentence. A statutorily mandated sentence like in Wall, like in General Statute 90-95H, which provides sentencing for trafficking offenses, like the habitual felon statutes, as was the case in State versus Kirkpatrick. Those are statutorily mandated sentences that Wagner highlighted have to be observed. A sentencing chart sentence, however, yields to 15A1335, and that is what the court got wrong. Lastly, I think it's important to point out that this is not a common issue. 15A1335 is only triggered when a defendant's conviction is set aside on appeal or collateral review, which would only happen if the conviction or sentence was unconstitutional or unlawful. Criminal cases that have a successful outcome on appeal is a very small number. For the fiscal year ending June 30, 2024, there were approximately 100,000 criminal cases in Superior Court. The majority pled guilty. About 2,000 of that 100,000 opted for a jury trial, and about 1,400 were found guilty by a jury. For that same year, the Court of Appeals filed 445 criminal case opinions in 445 criminal cases, and this court filed 24 opinions in non-capital criminal cases. The point is that the opportunity to apply General Statute 15A1335 is not common because it's a very small percentage and it's not vulnerable to abuse. Our legislature intended for 15A1335 to provide more protection than the due process protections offered in Pierce. The intent and plain meaning of the statute is clear, and this court further clarified its application in Wagner. The Court of Appeals decision restricted application of the statute beyond the plain meaning and contrary to this court's opinion in Wagner. So if there are no further questions, I would just conclude and ask the Court of Appeals decision be reversed and that Mr. Thomas be resentenced in the second judgment to a term that does not exceed the original sentence. Thank you.
Thank you, counsel. We're from the appellee.
May it please the court. My name is Ben Spangler. I'm an Assistant Attorney General with the Civil Division of the North Carolina Department of Justice, here on behalf of the state. The issue presented to this court today is whether a statutorily mandated sentence, or whether defendant's statutorily mandated sentence violates the provisions of General Statute 15A-1335. In short, no. Defendant's statutorily mandated sentence was the minimum sentence that the trial court was permitted to enter, and it did not involve the exercise of the trial court's discretion in doing so in violation of Section 1335. As a preliminary matter, I'd like to note that the defendant did not cite to nor discuss State v. Wagner, nor the language in General Statute 15A-1340.13b, which states, in part, unless applicable statutes require or authorize another minimum sentence of imprisonment. Rule of Appellate Procedure 28A and prior holdings of this court make it clear that defendant is precluded from basing their argument or from bringing new arguments based on these authorities essentially changing courses following an unsuccessful Court of Appeals case. A little background, we've talked, the appellate attorney has talked about defendant's sentence. Defendant was tried and convicted in a first trial, was successful in their appeal, and was awarded a new trial. At the new trial, defendant was sentenced again to two sentences. They were consolidated sentences. The first consolidated sentence was for the exact same term of years. Defendant does not challenge that the second consolidated sentence in the second trial was in any way violative of their rights. Defendant now only claims that the second consolidated sentence from the second trial violated Section 1335. It is worth noting that the trial court in the second trial for the second consolidated sentence consolidated the charge under the exact same case number and line number as in the first trial. The trial court did not deviate in entering that second consolidated sentence from the underlying leading charge. The only difference in the two sentences between the first trial and the second trial was the finding of the additional same elements point as discussed by the appellant. That additional point was statutorily mandated. The trial court did not have discretion to not find that point, and that is the reason why the defendant's prior record level was bumped up from a 3, which was errantly found in the first trial, to a 4, which was properly found in the second trial. Defendant doesn't contend that there was any error in his second consolidated sentence, but for his desired application of Section 1335. I'd like to begin with discussing some of the law that's applicable in this case, starting with North Carolina v. Pierce. That is a Supreme Court opinion. As you're aware, North Carolina v. Pierce stood for the proposition that a defendant can't be punished more severely on remand than they were at their initial trial. The Supreme Court discussed that vindictiveness against a defendant must play no part in the sentence he receives at a new trial. The Supreme Court did note, however, that that principle was not absolute and it was subject to exceptions. The Supreme Court discussed one exception in that case, State v. Pierce, where if there was evidence in the record that the new trial and the new sentence was greater than the original trial based on activity that the defendant engaged in between the two sentences, that would be okay. North Carolina has declined to follow that exception, but as we'll discuss here, other exceptions do exist in the law. The Court of Appeals considered this question a few times between the time of the enactment of Section 1335 and the State v. Wagner case that we'll discuss, I'm sure, at length. In State v. Williams, the Court of Appeals held that Section 1335 applied to instances where a trial court was reweighing aggravating and mitigating factors, and in doing so, imposed a greater penalty. And that's an exercise of discretion under our statute. The judge has the discretion on whether and how to weigh mitigating and aggravating factors. In State v. Williams, the trial court concluded that it didn't apply, that 1335 didn't apply in defendant's case. I'm sorry, that it did apply in defendant's case. It did not apply in defendant's case because the trial judge did not weigh aggravating factors, but merely imposed the minimum presumptive sentence of 14 years, which is what happened in the present case. State v. Kirkpatrick further narrowed this holding that where the trial court is required by statute to impose a particular sentence on resentencing, 15A 1335 does not apply to prevent the imposition of a more severe sentence. State v. Wagner is the case that the defendant wants you to look at, and it does discuss the interplay between Section 1335 and our other sentencing statutes. State v. Wagner, however, directly goes to that reweighing of aggravating and mitigating factors discussed in the Court of Appeals cases. In State v. Wagner, the defendant was originally sentenced as a prior record level 4 in the mitigated range, at the bottom of the mitigated range. Following appeal, defendant was not found to have any mitigating factors and was sentenced at the bottom of the presumptive range. This court held that in that situation, in the situation of reweighing, mitigating, and aggravating factors, 1335 did apply to prevent the imposition of the more severe sentence.
So do you agree with the argument by opposing counsel that here the trial court could have consolidated the offenses in the second sentence and the second proceeding differently?
I think we have evidence from the first sentence that the trial court did consolidate the sentence under a different leading charge. There's no issue with that. The state doesn't contend there's any issue with that, and the defendant did not claim that there was any issue with that. The sentence there was the same, and that's why 1335 was not implicated. The question of whether the trial court could have consolidated under the second sentence under a different leading charge, I would submit to Your Honor that that's not going to be an option for every court. And the rule that we follow has to apply to every case. For example, if a defendant is only charged with 2 charges, then there wouldn't be an option under no consolidation there, but there wouldn't be an option to consolidate or to enter a sentence under a different leading charge. Also, I think it would be improper to suggest that if a defendant is charged with an I felony, for example, and a handful of misdemeanors, that the trial court on remand should be forced to consolidate under the much lower misdemeanor in order to comply with 1335.
But that's not what's being suggested here. The other offense that could have been consolidated was the same level, so it wouldn't have violated the rule that consolidation should be under the most severe offense. And isn't the question here not whether in every case 1335 only applies if there's an option to consolidate under a different offense? Isn't the argument here that in this particular case there was discretion, and the court could have, consistent with all the other statutes that the General Assembly has promulgated regarding sentencing, completely consistent with all of those, the court here had the discretion to comply with 1335.
I understand what you're asking. I think the question is whether the court exercised its discretion in a way that suggests vindictiveness.
But tell me where in 1335 the defendant has to prove vindictiveness in order to take advantage or be covered by the statute. It doesn't say that anywhere in the statute.
It doesn't require the defendant to prove vindictiveness. That's correct, Your Honor. I agree with you on that. The statute, however, has Pierce as its underlying its statutory history, right? That's part of the reason for 1335, and Pierce does suggest that vindictiveness is why we are going to prevent a defendant from being sentenced to a greater term of incarceration upon remand.
But isn't our obligation to enforce the language of the statute as the General Assembly wrote it? And it's very clear. The court may not impose a new sentence for the same offense or for a different offense based on the same conduct, which is more severe than the prior sentence.
Yes, and I think, again, looking at Pierce, that principle is not absolute. It is not without exception. And
Well, but we're not. Yes, we should comply with the United States Supreme Court's opinions, but we also have to comply with the statutory mandates from the General Assembly.
yes, Your Honor, and that includes the structured sentencing statute. The structured sentencing statute contains a mandate. It's a mechanical statute. It's a calculation. It's a mathematical formula. And the purpose of that is to remove a certain amount of discretion from a trial court to eliminate the presumption or even the hint.
Right, but
of
then we're back
vindictiveness.
to whether or not this sentence was actually mandated or whether there was discretion in the trial judge. But even assuming that there was no discretion whatsoever in this particular circumstance, what are we to make? How can we read out of the structured sentencing statute the statement, unless applicable statutes require or authorize another minimum sentence of imprisonment? Why would we just read that out and somehow say, well, 1335 is not a statute that applies here? Why wouldn't it apply here?
I think if we consider some of the other cases, again, they come out of the Court of Appeals that talk about when it's appropriate to impose a greater sentence on remand. And they definitely talk about whether the original sentence was erroneous or illegal. In some of the cases use the term illegal. If the original sentence was illegal, the subsequent trial court should not be bound to impose an additional illegal sentence.
Except that that's the whole point of 1335 is to say, and if the defendant never appealed, then the illegality of that original sentence would have never been established, and he would have served the original sentence. And isn't the point of this statute to say that if a defendant successfully appeals and shows that he was wrongfully sentenced the first time, he can't be resentenced in a way that increases his sentence? That just creates a sort of a due process problem.
Your Honor, I understand what you're saying. Due process concerns were not raised by the defendant. I don't know that they're properly before the court today.
Well, I'm just saying they're embodied in the statute.
They are, and I think they're also embodied in Pierce. And vindictiveness is the purpose behind Section 1335.
So let me ask you about that. Because we're not the first people to wonder how much of Pierce is incorporated into the statute. And in the Code Commission commentary, it seems to say very expressly that the text of this statute is broader than Pierce on purpose, because it would have been hard to craft a rule that, I think the exact words were, that allows for the more severe sentence if the intervening factors would argue for that sentence. And they just couldn't craft a statutory language that they felt made that work, so it's broader. And I mean, wouldn't that be relevant here then? Because we'd say, well, we're obviously not just looking at the vindictiveness, we're looking at what the text of this statute says to provide a more workable rule. Would you agree with that?
Yes, Your Honor, I would agree. We do have North Carolina's Section 1335 is more broad than the holding in Pierce. It does not provide for the intervening conduct to justify a greater sentence.
So why can't we look to that and say, well, there's nothing that says 1335 isn't one of these statutes that you can consider in structured sentencing, say, okay, I have to provide a lower minimum. And then if you look at just our case law, this seems to be exactly the sort of case where, so I agree, you would have a stronger case if the court was truly compelled under the structured sentencing scheme to find that prior record level. But I think, as you've acknowledged, the court could have restructured the way it consolidated these offenses and not have that problem. So why shouldn't we look to that and say, this is just a narrow case that's not, it's in future cases where the court is stuck with structured sentencing, it's going to follow it. But here, this is sort of a special case where the court had discretion to do something different. Why shouldn't we just have that? It's similar to Wagner.
I think, Your Honor, that doesn't really cover all of what we're talking about here. Whether the court could have exercised its discretion to consolidate a sentence in a different way, that's not really the point. The point is whether the trial court did exercise affirmative discretion in order to provide for a higher sentence. If the trial court, for example, had changed the leading charge to a more severe penalty to get to a more severe punishment, then I would agree with you that 1335 is absolutely implicated. That was an affirmative exercise of discretion in order to impose a greater penalty. In this court, the trial court did not change the leading charge. The trial court did not exercise discretion to consolidate the charges under a different charge for the purpose of imposing a greater penalty. And I think for the purpose of is the important part here, because it comes back to whether the trial court acted or is perceived to have acted vindictively.
I'd like to ask you a statutory construction issue or question about 15A 1335. First of all, would you agree that in the absence of other provisions, on its face, 1335 would appear to prohibit what the trial court did here?
I agree, Your Honor. In the absence of the interplay with other statutes, 1335 is unambiguous.
Okay.
I think when you combine it with the other statutes where we have other mandates from the General Assembly that trial courts are expected to comply with, that's where we have some ambiguity.
Okay. I think then one issue for me is the last sentence of 1335, because it is an exception to what goes before it. So in 1335, you have, it seems to me, you can tell me if you think I'm wrong, but it seems to create this general rule. You can't impose a more severe punishment if the case goes back. And then there's an exception. Wouldn't we ordinarily say that because there's an exception here in the statute, that if the General Assembly had intended for there to be other exceptions, we'd find them here?
I think that's certainly one interpretation. I think also...
Why is it wrong? I assume you disagree, so why is it wrong?
I do. I don't think the General Assembly should be expected to spell out every single statute that they have already passed, that are already on the books, that should apply as an exception. This is a very narrow exception, is a very specific exception when 1335, when a defendant is not entitled to that protection. I don't think the General Assembly should be required to enumerate. It doesn't apply for structured sentencing. It doesn't apply for any number of other things.
Well, they could have said, just thinking in terms of language that would achieve what you're asking us to hold here, they could have said, except some other statute requires a higher sentence. And yet it's in the structured sentencing statute where they said, unless another statute requires a different minimum.
Right, and I think if both statutes said unless another statute requires a minimum, we would have a circular situation. So I think, again, we're informed by Pierce, and Pierce focuses on the trial court's exercise of discretion to vindictively punish a defendant for successfully prosecuting their appeal, for asserting their rights. And there is no evidence in the record that the trial court found the extra point or declined to consolidate under a different charge to avoid finding the extra point as a way to punish the defendant.
But aren't you asking us to read into the statute a standard that would be nearly impossible for defendants to meet? I mean, it seems to me it would be extremely hard to somehow marshal evidence to show that the trial court's purpose in increasing a sentence after someone has successfully appealed their first conviction was out of vindictiveness.
I think, Your Honor, the appellant cited to a case, North Carolina v. Shiloh, which is from this court from 2021, I believe. And in that case, it didn't deal directly with the issue that we're dealing with here today, but it did discuss the issue of vindictive prosecution, which is under a different standard from what we're talking about today. They did discuss 1335. And in that case, there was ample evidence that defendant pointed to or suggested that proved his case that the prosecutor was engaging in a vindictive prosecution. The prosecutor made public statements that said, I'm going after this guy, I'm going to refile new charges. But in that case, the prosecutor said, I'm going to try to get a sentence equal to what we got before. And this court held in that case that 1335 was not implicated because the prosecutor was just trying to get the same sentence. So I think there are opportunities for defendants to show evidence of vindictive prosecution, and I think they would have a different case if that were what the record showed.
But as you pointed out earlier in your comments about due process, this is not a constitutional challenge. This is a statutory challenge. We're construing statutory provisions, and so what we're after here is the intent of the legislature. And we have said over and over again that when the language of a statute is clear, we don't go beyond that. And so if we think that 1335 clearly says the trial court couldn't do what it did here, and that that's not inconsistent with 15A-1340.13 because of that unless applicable statutes exception, where does that leave us?
I think I would follow the Court of Appeals reasoning in cases going back to 1985, including State v. Williams, State v. Kirkpatrick, and State v. Holt, which discussed that 1335 was not absolute, and there was the exception that if the trial court was following a statutorily mandated sentence, the statute, that was proper.
It seems that you're saying you don't think that the plain language of the statute leads to an outcome that favorable to the defendant.
When read in conjunction with the rest of our statutes, yes, Your Honor. I will note, I understand that this court is not bound by the holdings of the Court of Appeal, but I would submit that these are long-established precedents by the Court of Appeals that have not been interfered with by this court's holding in Wagner. Those cases were not overturned, nor have the subsequent cases in Cook and Powell been overturned. Those were cases that the Court of Appeals in this case relied on.
So I'm sorry, just one more question. Well, I might have more than one. What's ambiguous in 1335?
I think read in conjunction with Pierce and the other statutes.
But we only get to see there's a kind of a circularity here. We only get to Pierce, I think, if we think that the statute is ambiguous. If we think the statute, that the meaning is clear on its face, I think our precedents say we don't go beyond that. So what, in your view, in 1335 is unclear?
I think it's unclear, Your Honor, the direction that a trial court would be following when they have a conflict between what the General Assembly has told them they must impose a sentence and what this section says that you shall not impose a different sentence. I think it's also important to note here, Your Honor, that the first sentence was erroneous. It failed to, as structured sentencing mandated, include the additional point for the same elements.
So your argument might be then, or I think this is what you're getting at, we may have two absolutes that conflict, and so then we have to decide what would the legislature want to happen in that situation.
Yes, Your Honor. Thank you. I think that's an appropriate way of phrasing it. We have two absolutes. We have the trial court stuck between a rock and a hard place, and we rely on Pierce for the motivation between 1335. We want to prevent the presumption or the appearance of vindictiveness. And if a trial court is following a non-discretionary, statutorily mandated sentencing scheme, such as the provisions of the Structured Sentencing Act that are at play here, there isn't a presumption of vindictiveness.
How much weight should we, if we get to the Criminal Code Commission commentary on this, how much weight should we give it in light of the last sentence that's in that commentary, which says the commission felt that the circumstances under which this exception to the rule would apply are so rare as to not merit the difficulty in drafting an intelligible statement of the exception. Basically, we'll leave it up to somebody else to figure out what this means.
I think that's an appropriate reading of that. I think they're asking this court to resolve some of those ambiguities. I do think it is important, we've talked a lot about discretionary versus non-discretionary. I do want to highlight that there are discretionary elements to structured sentencing. For example, whether to sentence a defendant within the mitigated, presumptive, or aggravated range, that is discretionary. That is entirely within the purview of the trial court, and also within each of those ranges where to sentence a defendant. Those are discretionary elements of structured sentencing. None of that happened here. What happened here falls within the non-discretionary elements of our Structured Sentencing Act. A trial court is not permitted to sentence a defendant outside of the appropriate range. Likewise, a trial court doesn't have the authority to enter a suspended sentence, for example, where a suspended sentence is not provided for under the sentencing chart. A trial court does not have discretion to ignore part of a defendant's criminal record. If a defendant was properly convicted of a crime, that counts for prior record level points. North Carolina General Statute 15A-1340.14 is mechanical. It's a math formula. There's no discretion in adding up numbers. It either is a number you include in the calculation or it's not. That includes the same elements point. If a criminal defendant has been convicted of a crime that includes the same elements for which the leading charge of that sentence includes the same elements, that point is mandated by statute to be applied. And that was the focus of the Court of Appeals opinion in this matter, and that was the issue that the defendant presented to the Court of Appeals, saying here, and this was their conclusion to this element in their Court of Appeals brief, here the trial court's decision to impose the additional point for the same elements was in violation of North Carolina General Statutes 15A-1335 because the additional point was not statutorily required and it caused the aggregate sentence from the second trial to exceed the original aggregate sentence. The trial court therefore erred when it sentenced Mr. Thomas to a term in excess of the term allowed under 1335. The Court of Appeals resolved that question by engaging in statutory interpretation and looking at the statute, looking at the clear meaning of the statute. They found some ambiguity. The word may did not appear, nor did the word shall. There was no mandatory or discretionary language in assessing the extra elements point. The Court of Appeals, however, said that the language of the statute suggested that there was no discretion in whether it should be applied. Non-discretionary sentencing under our Structured Sentencing Act, by its nature, eliminates the presumption of vindictiveness. The trial court, once they calculated defendant's correct prior record level point, did not have any discretion in whether to assess that point and find the defendant as a prior record level 4. Once doing so, could not sentence the defendant outside of the range as the defendant is now requesting. As evidenced by the prior record level finding calculation at the defendant's second trial, defendant was a prior record level 4 for the purpose of the breaking or entering a motor vehicle charge. The trial court did not have discretion to once again improperly calculate defendant's prior record level. The Court of Appeals, following Powell, arrived at the only conclusion that is possible under the facts of this case, holding, in the absence of any mitigating factors, the trial court was not statutorily authorized to impose any lesser sentence than the sentence entered. And then, quoting Powell, continued accordingly. North Carolina General Statute 15A-1335.
Counsel, I believe your time's expired. Thank you.
Your Honor, if you'll permit me 10 seconds to conclude, I would appreciate it.
I think we've heard your argument.
Thank you.
Rebuttal?
Excuse me. So I would like to start with that the state keeps saying that in the second trial, the judge just used the same consolidation that had been used in the first trial and did not deviate from that consolidation. But counsel fails to recognize that 15A-1340.15 gives the judge discretion on how to consolidate. They don't have to follow what was done in the first trial. This is a de novo sentencing. He is not bound by how things were consolidated the first time. So on resentencing, the judge had discretion to consolidate the felonies that remained, how he saw fit, and he went ahead and he did it in violation of 15A-1335. And then with respect to using the first trial as being an erroneous first sentence, there are other cases, as I mentioned before, Holt and Ransom, that use the erroneous first sentence as the benchmark to determine whether there was a violation of 15A-1335. And lastly, he cited to Powell about that was the case that the Court of Appeals cited to. And in Powell, that was a case that was remanded to the court, and it was remanded as a clerical error. The judge had changed the maximum sentence from what appeared on the sentencing chart to something else, and that was remanded for the maximum sentence to be changed to the correct number. There was no discretion there at all. And lastly, I would like to say the state keeps saying that this is a statutorily mandated sentence. And in Wagner, they specifically used Wall as an example to illustrate what is a statutorily mandated sentence. And they are things like habitual felon, such as the trafficking sentencing. But Wagner stated that if it's a sentencing chart sentence, according to 15A-1340.13b, it yields to 15A-1335. And so in conclusion, I would just like to ask that you reverse the Court of Appeals decision and that Mr. Thomas be resentenced in the second judgment to a term that does not exceed the original. Thank you.
Thank you, counsel.
All rise.